Welcome back to Courtview. The courtroom is heavy with legacy, a grandmother's ring, a father's fury, and a groom who thought he was polishing love into something grander. Tension builds as tradition clashes with modern taste. Mr. Johnson says the heirloom was ruined. Mr. Arbor says he added value out of devotion. The daughter beams with the new design while the father sees betrayal. This isn't just about carrots or market price, it's about who owns a family story. What really happened when trust met alteration, and who gets to decide a family's legacy?
This is the case of Johnson versus Arbor. Mr. Johnson, you are suing Mr. Arbor for $12,000, the cost of a family heirloom. Is that correct?
Yes, Your Honor.
And defendant, you claim that you actually added value to it and that it was a gift. Is that correct?
Yes, Your Honor.
All right. Let's start with you, plaintiff. What kind of heirloom is this?
Your Honor, I owned a family heirloom ring that belonged to my grandmother. It had antique value, and my daughter let me know that she was going to be married, and though my grandmother wanted me to use it, she was still alive when I proposed to my wife, so we used a different ring. She let me know she wanted it to go to my daughter.
All right.
She's always known that this was an important family tradition to pass this ring on.
So, Mr. Johnson, what happened to the heirloom?
I met Mr. Arbor, this gentleman, and I use that term sparingly, a few years back when my daughter brought him home, and I could tell that he had designs on my daughter, and it was more than a, flirtation. It was more than that.
Okay, you say designs. Designs seem
Design being that I could tell that he was in it for a long-term relationship.
Oh, okay. Designs seemed like you didn't approve. You mean you knew that he was really interested in your daughter?
Yes, Your Honor.
Okay. So what did he do to the ring? And how did he even get control of it?
My daughter knew she was getting this ring. I gave it to Mr. Arbor and made it clear that this was, in fact, a family heirloom, and I was passing it on to him to put on my daughter's finger.
Okay. Did you go, Mr. Arbor, and ask Mr. Johnson for your wife's hand in marriage, his daughter's hand?
I did. I know that their family, they're very invested in sort of family values, and that gesture would be important to him. And so I asked for his hand, even though I personally think it's an archaic tradition. I asked him, and I knew about the ring as well, and so he gave me the ring willingly for me to use.
And you accepted that?
I accepted it, yes.
And you were going to present that to his daughter?
Yes.
And so, Mr. Johnson, you're suing him for the value of it. If you gave it to him so that he could present it to your daughter, why are you suing him for the value of it?
Mr. Arbor we've had a relationship that has been, in a word, contentious. He's a very rude young man.
What did he do to the ring?
I gave him the ring and again informed him very clearly that it was a precious family heirloom. He took it to a cut-rate jeweler, I have to assume, and had the ring entirely refigured. It was a small, beautiful diamond. He added gemstones to it. Now it's horrendous.
So why did you go and take the heirloom to a jeweler, Mr. Arbor?
He gave it to me, and I recognized the importance of it, but it was also a very small ring.
Okay.
And I
small diamond?
It was just, a small gem, and overall, it was just not a very impressive ring. I took it to a family friend who runs a jeweler, and I just wanted to add some gems so that it could be a more fitting symbol of my affection. I wanted an impressive ring.
You were aware that it was his grandmother's ring and that it was very important to the family, and that's why he wanted to give it to his daughter. He wanted you to give it to his daughter for your engagement.
Yes, I knew that the ring was special, and that's why I modified it instead of just getting a bigger and more impressive ring. I thought that by modifying it, it would still have the family value.
Coming up.
He decides to alter it, and obviously, since you're here in court, You did not agree with that.
Not only did he destroy the structural integrity of this ring, he destroyed a family tradition.
Do you have a picture of this ring?
I do, Your Honor.
I'd like to see it, please. So you take it to the jeweler and say, listen, this is a family heirloom. I don't want to change it completely, but I do want to modify it to reflect my future wife's tastes.
Yes.
And then what happens?
So I think that it looked great. Lily thought it looks great. She really loves how it looks now.
This is the original ring?
That is the original ring before modification.
And then let me see the ring with modification. Who brought a picture of that?
I'm not sure if we have a picture, but she's wearing it.
Oh, please stand, ma'am. State your name for the court.
I'm Ronald Johnson.
All right, Miss Johnson, you are Mr. Johnson's daughter.
Yes,
right? You're wearing the ring right now. All right, please approach the bench and let me see this ring. And turn your hand a little bit. So you added a larger diamond.
I have a receipt of what I added.
Please pass that up. Thank you.
Okay.
Very beautiful.
So the main stone in the middle is the same, but I added a halo around it and diamond encrusted band.
So you give Mr. Arbor the heirloom, Mr. Johnson, and obviously since you're here in court, you did not agree with that.
I thought, once again, I had made it crystal clear the importance of this ring being my grandmother's ring,
You didn't say I couldn't change it.
my daughter's
To it.
great-grandmother's ring. He says he made the ring better. Not only did he destroy the structural integrity of this ring, he destroyed a family tradition.
All right. And so you were disappointed and you let Mr. Arbor know this.
Disappointed would be an understatement, Your Honor.
Understood. I'd like to hear from your daughter. Ma'am, Miss Johnson, so when Mr. Arbor asked you to marry him and he presented this ring, how did you feel when you got the ring?
I was overjoyed because it's still the tradition. It's still my grand stone, and it's something that reflects us too.
All right. So you were okay with the ring.
Yes, ma'am.
You were excited about a beautiful ring.
Mhm.
All right. Mr. Johnson, you're suing for $12,000. How is it that that ring was valued at $12,000? Where did you get that number from? And do you have any receipts that shows?
Your Honor, if you look at the other page of the paperwork I gave you, you'll see that I had that ring professionally evaluated in 2017. This is a gemologist, certified, and she said on open market, that ring, if sold, would be worth $12,000.
So this is the issue. That ring was supposed to be given to your daughter, right?
Correct, Your Honor.
Your grandmother had it. Your grandmother kept it, and upon her passing, gave it to you with the understanding that when my granddaughter Lily gets married, I want her to have that ring.
Absolutely.
And so it was your intention.
Judge Lake finds the gift was conditional and not complete until the daughter accepted it, meaning Mr. Arbor didn't have free license to alter the ring. Legally, this is about conditional delivery and intent. Possession held for a purpose does not equal absolute ownership. Emotionally, an act framed as romantic became unilateral interference with family heritage. The ruling elevates documented intent and family trust above aesthetic justifications.
By giving it to Mr. Arbor, that he was going to give it to your daughter.
He was middling the deal.
So the question this court has to decide is, was this gift given? Was it delivered, right? Upon the moment that you gave it to Mr. Arbor, was that gift given? If it was delivered, then once you gave it to him, then he could change it any way he wanted, even though it was insulting to you. But if that gift was completed and received and delivered and he accepted, then it's his to do with what he wants. But what the court's opinion is that the intent was to give the gift to your daughter. And until she received and accepted that ring was merely being cared for by Mr. Arbor, or even given as a gift with a condition that it goes to your daughter. Mr. Arbor, if you wanted to change that ring or alter it in any way, this court believes you should have consulted Mr. Johnson at the very least, right, before you made those alterations. That was not a ring that you had purchased. That was not a ring that was in your family. And your wife-to-be had never even seen the ring, worn the ring, and you did not decide together to alter the ring. Your better path was to give her the ring exactly the way it was. And if on the first anniversary you all decide to alter it, I'm sure Mr. Johnson would have still been offended. But at that time, the gift would have been complete and it would have been hers to do whatever she wanted with it. For that reason, it is the opinion of this court that Mr. Johnson is entitled to the $12,000, which is the value of the heirloom he entrusted you with. Judgment for the plaintiff. Court is adjourned.
Heirlooms aren't merely jewelry, they're vessels of memory and obligation. The law protects those intentions when delivery conditions exist. This case hurts because a gesture meant to honor became a source of fracturing. It shows the thin line between improving and erasing legacy. Would you have checked with the family before making such changes? And if you were the recipient, would you accept a modified heirloom or return it to its original form? This case unfolds between a daycare owner fighting to collect unpaid field trip fees and a single mother struggling just to keep up. What begins as a simple misunderstanding soon reveals deeper frustration, unclear agreements, and a child caught in the middle. When money meets miscommunication, who should carry the weight?
This is the case of Lopez versus Pierce. Miss Lopez, you are suing Miss Pierce for $225, which is the cost of unpaid field trips. Is that correct?
That is correct.
And Miss Pierce, you say you believe the trips were a part of a scholarship.
Correct.
All right. So, Ms. Lopez, let's start with you. What kind of trips were these?
So these were the field trips over the summer for the children. So
Or
for my daycare center. So
you own a daycare center.
I own a daycare center. And during the summer, we like to do fun things. I noticed that Miss Kelly's permission slips were not turned in. I approached her and I told her, I haven't received your permission slip. I mean, she could tell me that she couldn't do it or she didn't have time, something like that. But then at the end, she did say that she couldn't afford it.
How much was the field trip?
All three combined were $225.
Were you aware when you enrolled her that there were field trips in the summer?
I was aware that there were field trips. I just was under the impression that it would be more affordable. It's about $60 to $75 per field trip. And for a single mom, it's a little tough on top of tuition,
That
So
is expensive.
it is. We had a conversation when she approached me that I did not turn in the permission slip. And I told her, hey, look, my situation, I'm on a strict budget. I just can't afford it, And she told me, don't worry about it. Don't worry about the money. I want Allison to be, included in the field trips. So I took it as like it was a scholarship.
If you're paying for every day, you're now asking a parent to incur an additional expense because you all aren't there on the field trip day. $225. It's not cheap. What is your position? What is your business's position when a family cannot pay? Do they just say, we're going to turn the permission slip in, say no, and the child stays home that day?
No, this is in addition to the regular tuition. So if they cannot afford to bring their child to the trips, then they can find an alternate ways of having a babysitter.
Do you have a contract where they agree to that?
Yes, I have a contract right here.
Let me see that, please. Yeah, I'm just asking that because if you're paying for every day, you're now asking a parent to incur an additional expense because you all aren't there on the field trip day. So is that clear in your contract?
I know that it's clear in the contract that if I decline for my child to join the field trip, that I also have to find different childcare for that day. And that's what I offered for her. I offered, I'm not going to put my child on the field trip.
So you are admitting that in the contract, you did see where if your child doesn't go on the field trip, you do have to get alternative
Correct.
care.
And that's
And
why.
that's your responsibility.
Correct.
And you signed and accepted that.
I did. And that's why I told her that I was not going to have my child go on to this field trip. I couldn't afford it.
Okay, so let me get to the issue at hand, which is the miscommunication between you saying, don't worry about it, we'll worry about it later. You understanding, all right, we don't have to worry about it at all because they're just basically going to maybe give tuition assistance. Why is it there was no communication and you simply just thrusted this $225 on her?
She did tell me at first of that financial hardship that she was going through.
But did you ever make it clear to her that you don't have to pay it today, but I'll just need all of those fees by the time the summer's over? Did you ever say that anywhere? Do I have that in writing, a text message?
Well, it wasn't, well, no, I feel that you should have just come up to me because I was nice to you, and I allow you. I'm not fighting that I pay for your child, but I do have bills. I have 5 employees. I have 30 children. I'm a business owner.
I've heard enough. I understand both sides of this story. The problem is you did not make an arrangement with enough specificity. It was just kind of like, don't worry about it. Well, when is later?
Towards the end of July. I mean, I don't give freebies, Your Honor, okay? I have a business tour.
Right. But we're in a situation where I believe you wanted to put the child first.
Yes.
I do not think you were clear enough about when this money was due. For that reason, you guys are going to split the difference on this. $112.50 is the judgment for the plaintiff. Court is adjourned.
Judge Lake splits the cost, ruling that unclear communication created equal responsibility. And this case reminds us, assumptions can be expensive, and silence can turn small problems into courtroom battles. Would you expect the daycare to cover the outings, or should a parent pay no matter what the hardship is? If you found this breakdown helpful, like and subscribe to Courtview for more cases like this.